Welcome back to the deep dive. We're jumping right in today with a really essential topic, especially if you're grappling with family law studies.
Hmm.
Now, this deep dive is only possible because the University of London has generously made these, well, incredibly valuable documents available to students. We're sticking entirely to the material they've provided.
That's right. Analyzing the core concepts, the key cases, the arguments, it's all based on that source material, purely for educational purposes.
Exactly. And a big thank you. This deep dive is brought to you by Sinorbit Academy, Sri Lanka. We really want to wish all of you students the very best of luck for your upcoming exams.
Indeed. Good luck, everyone. And the area we're diving into today, it affects a huge number of people, and it's growing. We're
Yeah.
talking about cohabitation law in England and Wales.
Right. It sits alongside marriage and civil partnership law, but
That's
it's very distinct, isn't it?
very. And the source material points out just how relevant this is. Something like 1 in 8 British couples are living together without getting married or entering a civil partnership.
1 in 8.
Yeah.
That's, what, over 12%? That's not niche anymore. It's mainstream.
Absolutely. And they're doing it for all sorts of reasons. Maybe it's a deliberate choice. Maybe they can't marry for some reason. Maybe one wants to and the other doesn't.
Whatever the reason, they've built a life together. A home, maybe kids.
Exactly. But the law, historically, has really struggled with how to handle relationships that don't fit that traditional married mold.
So that's our focus today, unpacking that struggle.
Precisely. We need to pin down the legal definition of cohabitation, which, maybe surprisingly, isn't straightforward at all. Then explore the really significant legal differences between cohabiting couples and married or civilly partnered ones.
And tackle that big debate.
Yeah.
Are these differences just, justifiable legal distinctions, or is it actually discrimination?
That's the core of it. We want this deep dive to be your essential guide to understanding the legal landscape for unmarried couples. We're pulling out the key points from the source material, connecting the dots.
Helping you get a solid grip on it all. Basically, equipping you with what you need to discuss these ideas confidently and, yeah, feel ready for those exams.
So let's start right at the beginning. What is cohabitation in the eyes of the law? Seems simple, but legally, not so much.
You'd think. Living together, right. But the source material's clear. Defining it legally is tough because it covers such a huge range of situations.
Exactly. You've got students sharing a flat to save rent, right? Then maybe a couple dating a few months who move in together.
All the way to a couple who've been committed partners for 20 years, raised a family, share absolutely everything.
That variation is the problem. It forces the law to ask, should that deeply committed long-term couple automatically get the same rights and duties as a married couple, or should they be treated just like, say, those students sharing a house?
And the law hasn't really had a clear, consistent answer.
Historically, no. It's been fragmented, depends on the context.
So if it's so tricky to define, why does the law even try?
Well, it's been forced to try when it becomes necessary for a specific legal purpose. The most common one, highlighted in the source, is welfare benefits.
Ah, okay. When money's involved, the state needs a definition.
Pretty much. From the state's view, there's a fairness issue. If you consider a married person's income when working out their spouse's benefits.
Then seems unfair not to consider a cohabitant's income if they're living like a married couple. Otherwise, the cohabiting couple might end up better off on benefits.
That's the state's perspective, but then you hit the counter-argument.
Which is,
Well, married people have a legal duty to support each other. Cohabitants don't. Fundamentally, there's no legal obligation. So is it fair for the state to assume they're supporting each other just to cut benefits when the legal duty isn't there?
feels like a bit of double standard.
It's exactly that tension. The policy goal for benefits is often to create a level playing field. If a couple lives as if married, their legal status shouldn't make them better or worse off financially than a married couple.
So the state treats them like a married couple when it saves the state money.
That's certainly how it can be seen. And proving cohabitation for benefits. Well, the source mentions it sometimes involved quite intrusive investigations in the past.
Not ideal. But there's case law that helps define it.
Yes, thankfully. Courts needed criteria when this living together as husband and wife phrase popped up in various laws. And the key case, the one that gives us a working definition, is Kimber v. Kimber.
Kimber v. Kimber, 2001. And interestingly, it wasn't even about benefits originally.
No, it was about whether maintenance payments to a former spouse should stop because she was now living with someone else. But the guidance from Tyra J. in that case has become really influential.
Right. So Kimber v. Kimber gives us What? A checklist?
Not a rigid checklist, no, more like 7 questions the court should ask itself to assess the substance of the relationship. Let's go through them.
Okay, criterion 1 from Kimber v. Kimber. Are they living together under the same roof?
Sounds obvious, but it means sharing the same household as their primary home. Being away for work or holidays doesn't break that, if that's still their base.
Got it. Second, do they share tasks and duties of daily life?
Yeah, this is about the practical stuff. What the judge called mutuality in the daily round. Are they sharing chores, shopping, cooking, running the household together? How do they function as a unit day to day?
Makes sense. Third from Kimber v. Kimber, stability and permanence.
Is it just a temporary thing, or is it established? How long have they lived together? Have they had kids? Time is often key here. A few weeks sharing is very different from, say, 8 years, like in one of the examples.
Okay, fourth criterion. How are their finances arranged?
This is a big one. Is one supporting the other? Joint accounts. Sharing bills. Now, the source makes a good point. Just splitting bills doesn't automatically prove cohabitation in this sense.
But it's evidence. And one person paying for everything doesn't disprove it either, if other things point to cohabitation.
Exactly. The court looks at the whole financial picture. How intertwined are they?
Fifth point from Kimber v. Kimber, an ongoing sexual relationship.
This is in there because it's usually part of marriage, but the source is careful here. Its absence now doesn't disprove it, and its presence now doesn't prove it on its own. The key question is, has there ever been a sexual relationship? If the answer is definitely no, never, then it's very unlikely they'd be seen as cohabiting as if married.
Right. Sixth, children. How do they relate to any children involved?
Having children together is obviously strong evidence of a past sexual relationship and living as a family unit. And if one partner acts like a parent to the other's, child school runs, parent evenings, that sort of thing, that really supports the idea they're cohabiting.
Okay. And the final seventh question from Kimber v. Kimber. Public acknowledgement. How are they seen by others?
Yeah. Would a reasonable person looking at their life think they're an unmarried cohabiting couple? How do they present themselves to friends, family, the outside world? The source adds a good point. They might personally want to be seen as unmarried individuals.
But that doesn't stop the law looking at the reality of their shared life, especially for something like assessing benefits.
Precisely. The message from Kimber v. Kimber is, look at the substance, not the label. If they act like a married couple in these ways, the law might treat them as cohabiting for certain purposes.
Which brings us back to that feeling of unfairness. If the state uses this definition, applies these Kimber v. Kimber criteria, when it suits the state, like for benefits.
Why isn't it prepared to offer similar recognition, like financial relief, when that same relationship breaks down?
Exactly. It seems inconsistent.
It's a major point of criticism. The law demands this as if married standard sometimes, but often withholds the corresponding rights and protections of actual marriage when things go wrong.
Let's quickly test these Kimber v. Kimber criteria on that example in the source activity 3.1. Julian and Sue live together 8 years. Julian's child, Tim, lives with them. They have separate bedrooms. Interesting. But they go out together, share costs. Sue does school runs and shopping. Friends see them as a couple. Sue applies for benefits. Is Julian's income counted?
Okay, let's run through Kimber v. Kimber. 1, same roof. Yes, 8 years. Separate rooms don't negate sharing a house. 2, shared tasks. Yes, Sue's doing shopping, school runs, clear mutuality. 3, stability. 8 years is definitely stable. 4, finances. Yes, sharing household expenses. 5, sexual relationship. Maybe not now, separate rooms, but Tim living there suggests there was one. Remember, it's has there ever been? 6, children. Yes, Tim lives there, and Sue is acting in a parental role. Very strong indicator. 7, public view. Yes, friends see them as a couple.
So even with separate bedrooms, weighing everything up using the Kimber v. Kimber factors, it looks highly likely to be considered cohabiting, as if married, for that benefit assessment.
Yes, based on those facts and the established criteria, that would be the probable outcome. It shows how the law digs into the reality beyond just, say, sleeping arrangements.
Right, so that clarifies how the law tries to define it when needed, using cases like Kimber v. Kimber. Now let's get to the real heart of it. The massive legal differences between cohabiting couples and married or civilly partnered ones. This is section 3.2, and it's where the common law marriage myth really does the damage.
It really is. And just to be clear, when we say spouse here, it generally includes civil partners too, unless stated otherwise. Their legal positions are mostly aligned now.
Okay, so difference number 1, formalities.
Marriage and civil partnership are formal, legal constructs. There are rules for starting them, rules for ending them, divorce, dissolution, nullity. The The state is involved.
And cohabitation.
Nothing. No register, no state process to start or end it. People just start living together and then they stop. The state stays out of it.
What about children and parental responsibility? PR.
Big difference here for fathers. Mom always gets PR automatically. A married dad also gets PR automatically.
But an unmarried dad.
No automatic PR. He has to actively get it, either by being on the birth certificate, making a formal PR agreement lodged with the court, or getting a court order under Section 4 of the Children Act 1989.
So an extra legal step needed for unmarried fathers.
Exactly. Though, as the source says, in practice, courts usually grant PR if the dad's involved, and it mainly matters if there's a dispute. We'll cover that more in Chapter 8. And it's worth noting, unmarried couples can adopt together if they're stable. That's in Chapter 12.
Okay, now the big one. The one that causes so much trouble on separation. Financial support and property.
This is, without doubt, the single biggest difference. All those laws and court powers for sorting out money and property when a marriage or civil partnership ends, maintenance, dividing assets, pensions, none of that applies to cohabiting couples. Those powers are covered in Chapter 6, but only for married CP couples.
So if a cohabiting couple splits up after years together, how do they sort out the house, the savings?
It's tough. They have to fall back on standard property law and equity things like trust law, which wasn't really designed for family breakdowns. They can ask a court to declare who owns what based on contributions or agreements.
But the court can't just step in and redistribute things based on fairness or need, like it can in a divorce.
No. That broad discretionary power to achieve a fair outcome based on all the circumstances, it's missing for cohabitants. And there's absolutely no legal obligation for one cohabitant to financially support the other after separation. No cohabitant maintenance.
What about child support, though?
Yes. Child support is different. The rules apply equally to married and unmarried parents. The law rightly focuses on the kids there. The gap is purely about support between the ex-partners themselves.
The source mentions cohabitation contracts. Are they way around this?
They can be. Couples can make a formal agreement about finances during their relationship, and crucially, what happens if they split. Their enforceability was looked at in Sutton v. Mishkondaraya back in 2004. It allows couples to create their own rules where the law provides none.
Okay. What about when someone dies without a will? Inheritance.
Huge difference again. If you die intestate, the law dictates who gets what. A surviving spouse or civil partner automatically inherits under these rules.
And a surviving cohabitant.
No automatic right to inherit anything. Zero.
Wow. So a partner of 30 years could be left with nothing automatically.
Correct. To get anything from the estate, the surviving cohabitant has to make a court application under the Inheritance Provision for Family Independence Act, 1975.
And they have to prove something to succeed.
Yes, under the 1975 Act, they have to show they lived with the deceased in the same household for the 2 years right before the death, as if they were married or civil partners. Ree Watson is a case mentioned that dealt with interpreting that living as the wife's standard for the act. So you see the impact. The bereaved cohabitant faces a potentially stressful, expensive court case just to ask for provision, while the spouse inherits automatically. It can be devastating, especially if the shared home was in the deceased's name only.
That really brings it home. Let's talk about property rights specifically regarding the family home.
Married couples and civil partners get special protection under the Family Law Act 1996. Section 30 gives them home rights, the right to live in the family home, even if they don't legally own it. There are also protections if the owner goes bankrupt under the Insolvency Act 1986.
And pension sharing is allowed on divorce.
Yes, under the Welfare Reform and Pensions Act 1999.
Do cohabitants get any of these? Home rights? Pension sharing?
Nope. None of those specific statutory rights apply. A cohabitant's right to stay in the home depends purely on ownership or complex trust arguments. No automatic pension sharing on separation. No equivalent of a widow's pension if their partner dies. Activity 3.2 asks you to think if the law should be more flexible here, referencing the burden case context.
What about tax? Are there differences there too?
Oh, yes. Big ones. Inheritance tax. Property passing between spouses on death is exempt. Inheritance Tax Act 1984. Massive benefit, often saves selling the home. Capital gains tax. Transfers between spouses aren't usually chargeable gains. Finance Act 1988.
And these tax breaks not available for unmarried couples.
Correct. Another area where formal status brings financial advantage.
Citizenship is mentioned briefly too.
Yes, marrying a UK citizen generally means less strict requirements for naturalization compared to just cohabiting with one.
Okay, are there any areas where the law has caught up and started treating cohabitants more like spouses. The source mentions tenancy succession.
Yes, this is a good example of change. Laws allow family members to take over a tenancy if the tenant dies. Initially, family was interpreted narrowly. The Court of Appeal in Fitzpatrick v. Sterling Housing Association first said a same-sex partner wasn't family for this.
But the House of Lords disagreed.
They did, and the position was cemented in Godin v. Godin-Mendoza in 2004. Now, laws referring to a spouse or family for tenancy succession are read to include both opposite sex and same-sex cohabitants in stable relationships. So here, the distinction is gone. It shows reform can happen.
That's positive. What about domestic abuse protections?
The Family Law Act 1996 provides key tools, non-molestation orders to stop harassment, and occupation orders about who lives in the home. Importantly, both spouses and cohabitants are associated persons under Section 42.
Meaning both can apply for non-molestation orders.
Yes, equal access there. For occupation orders, cohabitants can apply too, but, and here's the difference, if the cohabitant applying doesn't own the property, it's generally harder for them to get one, and it might be for a shorter time than a spouse might get, even if the spouse doesn't own it either but has those home rights. Chapter 5 details this. So protection exists, but it's not quite identical regarding occupation orders.
The Fatal Accidents Act 1976 also differentiates.
It does. Allows dependents to claim damages if someone's killed by negligence. Spouses can claim automatically in certain situations. Cohabitants can qualify, but only if they live together as if married for 2 years immediately before the death.
Another hurdle for cohabitants not faced by spouses.
Exactly. Let's use activity 3.3 quickly.
Right.
Trisha lives with Marcus. They have a child, Ben, not married. Trisha dies in an accident caused by negligence. No will. What problems does Marcus face?
Okay, well first, intestacy, no automatic inheritance for Marcus. He'd have to apply under the Inheritance Act 1975, prove the 2 years as if married. Second, for a Fatal Accidents Act claim, same problem, prove the 2 years as if married to qualify, unlike a spouse.
Precisely. It shows how these different rules stack up against unmarried partners in tragic circumstances. It all flows from that lack of formal recognition.
What about criminal law differences?
Some historical ones are gone. Marital rape, thankfully, was abolished in RVR in 1991, confirmed by the Criminal Justice and Public Order Act 1994, so the definition of rape is the same now, regardless of marriage.
And the old defense of a wife being coerced by your husband.
Also abolished by the Antisocial Behavior, Crime, and Policing Act 2014. More progress there.
But some criminal law distinctions remain.
Yes. Theft. You need the Director of Public Prosecution's consent to prosecute a spouse for stealing from the other spouse. Theft Act 1968. Not needed for cohabitants. Conspiracy. But you can't be guilty of conspiracy if the only other person involved is your spouse. Criminal Law Act 1977 doesn't apply to unmarried couples.
Okay. Law of obligations, tort and contract.
Tort law, mostly aligned now. Old ideas about spouses suing each other or deceit have largely gone. FRB v. DCA in 2019 confirmed that for deceit, the distinction is gone.
But contract law, especially agreements about finances.
Still a difference. Prenups for married couples are considered, but courts can still override them based on fairness principles from divorce law, Chapter 6. Cohabitation contracts, however, are more likely treated as standard contracts, making it potentially harder for a court to interfere if circumstances change.
What about keeping secrets? Marital confidences.
Yes, confidences shared in marriage are legally protected since cases like Argyle v. Argyle in 1967. But importantly, this protection was extended to cohabitants in Stevens v. Avery in 1988. And now it's viewed through the lens of human rights, Article 8 ECHR, right to private life, like in Douglas v. Hello, LTD. So essentially, the distinction regarding confidentiality has been removed here too, another area of alignment.
Good. Now, a really big one, the law of evidence. How are witnesses treated differently?
Yes, this is crucial, especially in criminal trials. A spouse is competent to testify. They can give evidence against the other spouse, but generally they are not compellable. They can't be forced to testify.
Can't be forced. Are there exceptions?
Yes, major ones under Section 80 of the Police and Criminal Evidence Act 1984, notably, if the charge involves violence against the spouse or violence or sexual offenses against someone under 16. In those cases, the spouse is compellable.
What about civil cases?
In civil cases, a spouse is both competent and compellable. They can be forced to testify.
So in criminal cases, a spouse often has a choice whether to testify, unless it's one of those specific serious offenses.
Broadly, yes. Now, the huge difference. These rules about non-compellability do not apply to cohabiting partners. That was confirmed in R.V. Pierce in 2001.
Meaning?
Meaning a cohabitant is both competent and compellable in all cases, criminal and civil. They can always be legally forced to give evidence against their partner.
Wow, that is a massive difference. Let's use Activity 3.4 to illustrate.
Hmm.
Surya and Amandeep are married 5 years. He's charged with car theft and raping a 14-year-old. Surya knows he did it. He confessed to her. Can the prosecution force her to testify about the confession?
Okay, they're married, she's competent. For the car theft, not an offense listed in the Section 80 exceptions, she is not compellable. They can't force her testimony on that. For the rape of a 14-year-old, that is a specified offense under Section 80, so she is compellable. They can force her to testify about that charge, potentially including the confession.
Right. Compellability depends on the crime, because they're married. Now, what if Surya and Amandeep were not married, just cohabiting?
Then the spousal compellability rules don't apply at all. She would be competent and compellable for both the car theft and the rape charge. She could be forced to testify against him on everything.
That's incredibly stark. It shows the law still holds on to a unique, protected status for marriage in evidence law, even if limited now.
It's one area where legal status has a very direct, practical impact in court.
Finally, the source touches on some more theoretical historical differences. Doctrine of unity and consortium.
These are more like legal history footnotes now. Unity was the old husband and wife or one-person idea, mostly legal fiction now, effects removed by law. The source mentions that on a 1945 railway ticket case and Midland Bank Trust Co. v. Green, no 3 regarding conspiracy, but questions if it'd fly today. Minimal relevance.
And consortium.
A fuzzy concept, the right to the spouse's society, comfort, etc. Munby J. acknowledged it still exists in Sheffield CCVE in 2004, but it has little practical effect. It's maybe just a symbol of marriage as a special relationship in law.
So these symbolic ideas apply to marriage, reinforcing its unique status, but not to cohabitation.
Exactly. They reflect the traditional legal underpinning.
Okay, let's try to summarize this huge section on differences. We've seen clear distinctions favoring married CP couples in formalities, finance on breakdown, property rights like home rights, inheritance, tax, some criminal rules, and crucially, evidence compellability.
But we also saw areas where the gap has closed. Tenancy succession, Godine, confidences, Stevens, rape definition, RVR, most torts, FRBV, DCA. It shows the law can change.
And hanging over all of this is that damaging myth of common law marriage. People think they have rights, they just don't, leading to shock and hardship when things go wrong. The source cites Barlow et al., 2005, and the Center for Social Justice on this real-world impact.
It's a huge disconnect between perception and reality, and it fuels the calls for reform, which takes us to Section 3.3, further reform.
Right. Given all these disadvantages, especially for vulnerable partners, reform seems overdue.
It's been on the agenda for years. The Law Commission did a major review.
Their key proposal.
Their big report, Cohabitation, the Consequences of Relationship Breakdown, Lawcom 307 from 2007, proposed a new statutory scheme. It would give courts powers to provide financial remedies for eligible cohabitants on separation or death, tailored, not identical to divorce, but providing some relief.
But the government didn't enact it.
No. As of the source materials date, the government decided not to take it forward. It depends on political will and priorities, but the issue hasn't vanished.
The source mentions more recent activity.
Yes, the debate bubbles away. A House Commons Women and Equalities Committee held an inquiry into cohabitant rights. The Commons Library keeps producing briefings. Parliament is still interested.
And MPs who've tried to bring in laws themselves.
Yes, through private members' bills. Lord Mark's Cohabitation Rights Bill, 2019-21, is mentioned as one recent attempt to create statutory protections. These bills often fail without government support, but they keep the pressure on.
Can we learn from elsewhere? Scotland.
Yes, Scotland introduced some measures in their 2006 Act allowing financial claims after cohabitation ends. It's not full divorce rights, but it gives courts some power. The UK Supreme Court looked at this in Gow v. Grant in 2012. Baroness Hale famously commented that England and Wales could learn from Scotland about the practicalities and fairness of such schemes.
So reform is still very much a live issue, even if progress is slow, which leads to the fundamental question underlying all this. Discrimination or difference? Section 3.3.1.
This is the core philosophical debate. Is the current legal setup a fair recognition of different choices, marriage versus cohabitation, or is it unfairly discriminating against a huge group of people in committed relationships?
The arguments for discrimination seem pretty strong, especially after Ree Brewster.
Ree Brewster is key. UK Supreme Court, 2017 Northern Irish case. But relevant principles. It involved a pension scheme. Surviving spouses' CPs got pensions automatically. Surviving cohabitants had to jump through extra hoops, proving financial dependency.
And the Supreme Court said,
Unanimously said that extra hurdle violated the Cohabitants Human Rights Article 14 ECHR, non-discrimination, combined with Article 8, private family life. Even if the aim was equal treatment eventually, the method was discriminatory. So Brewster strongly supports the argument that treating cohabitants differently can be unlawful discrimination. It really sharpens the question. Why should a couple who lived together for decades, maybe raised kids, be treated as legal strangers financially upon separation or death just because they didn't get the piece of paper? Lawcom 307 recognized the potential for real hardship.
and it feeds back into the common law marriage myth problem people suffer because the law doesn't match their reality or expectations. Barlow highlighted this, and the Center for Social Justice talks about it as a social justice issue impacting children too.
The argument is the law isn't just differentiating, it's actively discriminating by failing to protect people in substantial family-like relationships.
Okay, that's the discrimination argument. But the source, referencing Herring, also presents arguments for differentiation, that the current system is justifiable.
Yes, there are counter-arguments. One is benefit to the state. The idea, seen in government papers, is that marriage provides stability, especially for kids, so the state has an interest in promoting it and maybe treating it specially. The formal start-10 processes are seen as useful for regulation. Plus, maybe married couples are more likely to care for each other, saving the state money.
The obvious response is, shouldn't the state focus on the function of the family's stable care, regardless of the parent's marital status?
A valid point, but the benefit to state argument persists. The second big defense is choice.
Ah, yes, the autonomy argument. If a couple chooses not to marry, maybe they don't want the legal ties. Should the law respect that? Imposing marriage-like rules undermines their freedom.
It's a powerful argument, often used to resist reform. The counter, though, is that it often only respects the choice of one partner, the one who didn't want marriage. What about the partner who did want the security but was refused? Upholding the choice of one can leave the other vulnerable.
So, choice isn't straightforward. What about current attitudes?
Society largely accepts cohabitation now. So, should the law reflect that by removing penalties or disadvantages? That's the argument from changing social norms.
And finally, the radical abolition idea.
Yeah, if differentiation is problematic, maybe don't give cohabitants marriage rights, just abolish legal marriage altogether. Treat all relationships equally under one framework. Slaughter, 2000, argued marriage historically disadvantaged women. But, as the source says, there's virtually no support for this currently.
So we're left with this tension. Is the law discriminating? Reed Brewster, hardship, myth. Or is it justifiable differentiation? State interest, choice. Activity 3.6 asks you to weigh these. Can the law stop discrimination but still respect the difference of choosing not to marry?
It's a complex balancing act, autonomy versus protection, state interest versus individual lives. Analyzing these competing arguments is crucial for your understanding.
Okay, we've covered so much. Defining cohabitation, Kimber v. Kimber. The huge legal differences, finance, property, inheritance, evidence, etc., versus areas of convergence, Gideon Stevens. Reform efforts, Lawcom 307, Kamiki Grant. And the core discrimination versus differentiation debate, Reed Brewster.
And all this, drawn from the source material, is exactly what you need for your family law studies and exams. Let's quickly look at those sample exam questions.
Question 1 asks, should the law treat all family partnerships equally? Implications. Differentiate or discriminate?
The source advice is good. Tackle all parts. Argue for against equality, start interest. Discuss implications of equal treatment across all areas. Weigh against differentiation arguments, choice, state benefit. Then nail the discrimination versus differentiation point using Reed Brewster, Herring, ECHR, maybe mention Lawcom options like opt-outs.
Question 2 is more provocative. Giving cohabitants rights destroys their freedom, creates problems. Bonanza for lawyers. Discuss.
Here you engage directly with the choice argument. Would rights destroy freedom or provide options, especially with opt-outs? Discuss the problems of definition, back to Kimber v. Kimber difficulties, and address the bonanza for lawyers point. Yes, new laws mean litigation, but does the current lack of clarity also cause legal fights under property law?
Key advice for both. Form a strong, reasoned argument. Don't just sit on the fence. Use the cases, statutes, and concepts.
Absolutely. Referencing Kimber v. Kimber, Ree Watson, Godin v. Godin Mendoza, Ree Brewster, Gall v. Grant, the Inheritance Act 1975, FLA 1996, PACE E 1984, Lawcom 307 that shows your understanding and builds your case. Know what each one stands for.
So final key takeaways for exams.
1. Defining cohabitation is hard, but courts use criteria like Kimber v. Kimber, focusing on substance.
2. Know the big legal differences favoring marriage, finance, property, inheritance, evidence, and the areas where distinctions are gone. Remember the common law marriage myth's impact.
3. Be aware of reform efforts. Lawcom 307, Scotland Gavi Grant. 4. Critically engage with the discrimination, Ree Brewster, versus differentiation, choice, state interest, debate. That's central.
Getting to grips with these points, using the cases and laws, forming your arguments, that's the path to success here. Definitely use the further reading and the source to explore the academic arguments more deeply.
Indeed, it's vital knowledge, not just for exams, but for understanding modern family life and law.
So that concludes our deep dive into cohabitation law in England and Wales, the definition, the differences, the reform debate, the fairness question, all based entirely on the University of London's materials for your educational benefit, and brought to you by Sinorbit Academy, Sri Lanka.
Good luck to all of you for the exam.
Yes, very best of luck. And a final thought to ponder. If the law respects the freedom not to marry, which currently leaves people potentially unprotected, is it fair when that freedom leads to hardship for a partner who perhaps didn't fully grasp the legal void? Or should the state provide a basic safety net for all committed relationships, whatever their label? Something to think about as you revise.